So we'll get started. It's Mark Gregory here, starting the industry session number 6. We'll be talking about the law, cyber diplomacy and e-governance. And introduce people in the panel. We'll have myself, Mr. Patrick Fair, and also Dr. Henry Wolff from New Zealand. We're going to kick off the session with a presentation by Dr. Wolff. I'll hand over to him. Thank you.
Okay, thanks. Thanks for the opportunity to speak here today. I thought it might be instructive to talk about some of the players who have a vested interest in the idea and the space of digital diplomacy. And if we take a look at state players, here are some examples of national players. We call it advanced persistent threat groups, and you notice the one at the top, the very largest one in the world by 10 times probably, is the National Security Agency, which is a threat model just like all the rest of them. So it matters not what country it's from, but they're all intruding and getting into your network and doing things there where they don't belong without being invited to do so. We take a look at the National Security Agency. It's got connections with the Five Eyes, and those are the 4 countries involved. There are a number of operations that they've mounted, PRISM, which has been revealed by Edward Snowden, and those companies are all working in league with NSA to provide information for them. It has XKey Score, which has a number of other elements that it collects information and data from. Bull Run is one that's close to my heart, and that's a 10-year operation designed specifically to compromise all publicly available cryptography, which they spend $250 million a year on. So all of the crypto that you're using, most of it is likely to be compromised by NSA, put backdoors in. We have a whole bunch of other ones, and the list goes down off the board onto the floor somewhere that Snowden revealed, and those are only the ones that he revealed. NSA is a huge monster, and many, many, many more that are not revealed there. Shot Giant was interesting since John Lord was here yesterday, and claims have been made that, well, Huawei has got backdoors and they're going to do all of this and it's bad and all of that. Well, Shot Giant, interestingly enough, is an attack, an operation by NSA to attack Huawei. Now, I don't think Huawei attacked the Americans or anybody there, because there is no evidence, and if there was, we'd see it. It would be out in front of us. Everybody'd know about it because they'd want to publicize it. But there is no evidence, and jurisprudence calls for evidence before conviction. Okay? Not so. What they did was they broke into Huawei's servers in Shenzhen. They stole executive emails. They downloaded proprietary source code, which is what they accuse the Chinese of doing. They did it themselves, and this is documented. Not a very good thing, I don't think. And they've got a lot of other things too. Let's go on. Past that. This is one of NSA's principal advanced persistent threat units. It's in San Antonio, Texas. Employs 2,000 people. Their sole position, their sole jobs are to do things like break into systems and develop tools for breaking into systems. Kind of a pervasive sort of a thing. As you can see, it's a big, big operation. In Bluffdale, Utah, you say, okay, well, if NSA is collecting all this information, it's impossible to store all the information in the world anywhere. Well, they're making a good start at it, and Bluffdale currently has, it was opened in 2013, the ability to store 5 zettabytes of data. When I found out, I had to look it up. I didn't know what a zettabyte is. Maybe everybody here does, but I didn't know. And if you think about a billion terabyte drives, that's 1 zettabyte. So you know the physical volume of a terabyte drive, right? That's a billion of them, or in this case, 5 billion of them. It's a huge complex, costing billions of dollars, and that's where they store all the information. Now, people talk today about big data, and 40 years ago, we were talking about big data in Washington as well. And so what they've developed since then to handle large databases is way streets ahead of what we see in the public arena today. So you know that not only can they store it, but they can deal with it and handle the data. So if we're being constantly, as you went back there, you saw if you have nothing to hide, you have nothing to worry about. A lot of people think that's okay. I don't have anything to hide. I don't have anything to worry about, right? But the fact is, we all have something to hide. And it has certain ramifications to our behavior, right? It's an agenda by those who want your data. They want to intimidate you, make you feel like you're wrong or bad. But the fact is, because we want to hide something or keep something private or secret, that doesn't apply any condition to that data or that information. That data can be illegal. It can be perfectly innocuous. I mean, how many people in this room do not have a door on their bathroom? What are you hiding? Got nothing to hide, right? So come on, let's got to get real with this whole idea. Richelieu said, if you give me 6 lines written by the hand of the most honest man, I will find something in them which will hang him. Now, who here hasn't said something that fits that profile? All of us, I'm sure. And when you take information or data or statements out of context, you can apply them in all kinds of circumstances to make you look really, really bad. Continuous surveillance does alter our activities, how we behave, who we associate with, what we say, what we write, and all kinds of issues. Takes away our autonomy is what it does. So it's a bad thing in the main. And quite frankly, if all of you here, I'm sure, have cell phones, you are being surveilled every second of every minute of every day of every week, whether the phone is on or off, doesn't matter. And in fact, there's been some studies showing that if you took the SIM card out of the phone, turned it off, walked around all day, at the end of the day, put the SIM card back in, you would contact Google and send 300 megabytes of data about what you did all day. So the only way to stop that is put it into a Faraday bag or enclose it in aluminum foil if you don't want to be tracked. So it modifies our behavior. It's a human condition, guaranteed to all of us. Privacy is guaranteed to all of us by the Universal Declaration of Human Rights, which was signed, by the way, by Australia and New Zealand, who both are abrogating that document, in 1948 with 46 other countries. So based on that, and in some law, and in America, the Fourth Amendment provides the same kind of guarantees from 1776 or 78, 1791, sorry. In the Fourth Amendment guarantees the same thing. And yet they have abrogated that as well because NSA collects everything. So that's the government people. So they have a vested interest in not having digital diplomacy. If they were to lock down the internet and not allow stuff to happen, that would hinder their programs, seriously hinder their programs. But we also have the business sector. And here are some players in the business sector who would definitely be hindered dramatically if we shut down the internet and made it a private communication system, really, truly private. And Darth Vader is deliberate. They are from the dark side. How many here have gotten a dividend check from Google this year? How about Facebook? Anybody get a dividend from Facebook? Oh, okay. So these people make a lot of money by taking our information. By the way, you have agreed to it, tacitly or otherwise, and selling that information so we all are the product. It's been said many times. These are some of the things, just some of the things that Google collects about every one of the players that it connects to. Remember, if you have Google, if you do Google searches, they're collecting that information. If you have an Android telephone, they're collecting it by the second about what you are, what you're doing, where you are, and all the other information that happens that they collect at that level. If you use Gmail, they're not only collecting the metadata. People say, well, it's only metadata, but they don't do just metadata. They do deep packet inspection, which means they look at the content of your email. And if Mark and I have a discussion and I said I need a pair of back tires, probably tomorrow I'll start getting advertisements for tires. Okay? Because that's how that works. And they've monetized all of our information. In fact, in 2002 was the first year they made a profit in that company, Google, and it's because they monetized it in 2002. And ever since then, Surveillance capitalism is their invention. It's been adopted by other companies, like Facebook, for example. And Facebook collects a lot of stuff, right? So much more than you might think. And they collect it not only from you, but from people who know you or post things about you. So if I post a picture of Mark on my Facebook account, they will facial recognition that image to find out who he is, and then that'll be connected with me in some way. Okay? And they do that with all kinds of information, plus they collect it from their other owned subsidiaries. This is the one that I always like to show people, but you have, if you're using Windows 10, you have agreed to this. And this is the privacy statement in the service level agreement you have agreed to. What does it say there? It says, we will access, disclose, preserve all personal data, including your content, such as the content of your emails, other private communications, or file in private folders, when we have a good faith belief that doing so is necessary, which means they collect all your information and share it with whomever they please. And you've agreed to it if you have Windows 10. Don't you feel good about that, right? So last year, Google made $109 billion. $96 billion of it, 87%, was made from selling our data. That's why I asked you if you got a dividend, because they made a lot of money on our data, didn't they? We should be getting a dividend, don't you think? Facebook only made $40 billion last year, but they didn't make hardly any other revenues. Most of it was advertising. And that's why I asked you if you got a dividend from Facebook, because I don't think you did. Most people don't. Pretty bad, actually. This is the Fourth Amendment, guarantees our right to privacy. This is the Universal Declaration of Human Rights, signed in December of 1948. And that's the exact wording of what it is. No one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence. You know your computer activity is correspondence. It's electronic correspondence, but it nevertheless is correspondence. Nor pacts upon his honor and so on. And 48 countries signed up to it, including Australia and New Zealand, which both abrogated, and the United States as well. So they have a vested interest in nothing happening, don't they? Because that will significantly and dramatically influence their financials and their business model, because they wouldn't be able to get all of that information. I guess the closest thing that anybody's doing to help, I forgot one other category, is the hackers who do it because they like to. And because they can make money doing it by stealing things. And because they like to disrupt things. If you're a furrier, you are under attack by people who hate people who kill animals. I mean, there are all kinds of reasons. That's not a bad reason, but nevertheless, it's not as direct and as you might think. There's lots of different reasons why hackers go in and disrupt and do damage. And they're a third kind of a group. They wouldn't want the internet to be shut down either. So in the GDPR, I don't know what I'm doing to make that noise. I hope, sorry.
It's getting a bit close to it.
Okay. In the GDPR, here are only 3 of the elements. There are many more elements that are outlined in the GDPR, but these are kind of important ones. If you go to Facebook and you say, I want to see my record, they have to provide it if you're in the European Union. Not here, but in Europe. And if Facebook refuses or doesn't provide it to you free, then you can see this is their penalty, 4% of their global turnover. That's a lot of money for Google, right? 4% of $106 billion is a lot of money. So some of the things that are required, you have to be given clear consent. So you know that you have consented to providing your information or allowing them to use it. You have the right to access your information so you can see what they have about you. And Facebook and others get information from other sources, not just from their own application. And you also have the right to be forgotten, which means you can tell them to shut down your account, delete it, get rid of it. You don't want it put out there ever again. And if they violate any of those things, 4% is the penalty. So the notion of digital diplomacy, I think, while a laudable idea, and hopefully maybe it'll happen, there are too many vested interests that I just explained to you who don't want it to happen. they have too much at stake. And we're not talking about nickels and dimes here. We're talking about billions and billions of dollars. That's not even looking at the cell phone industry, which is $1 trillion business, and you're under constant surveillance with that device because it's the most effective, most efficient, pervasive surveillance device ever devised by man. Yeah, it's a telephone too, but it has all those other features as well. And that just was short. I didn't do too bad. 10 minutes, 15 minutes.
Thanks very much, Hank. I would like to continue the session now by inviting Patrick to give a talk. Thank you, Patrick.
Thanks, Mark. Hi, everybody. I'm Patrick Fair. I'm a partner at Baker McKenzie, and I also chair the Communications Security Reference Panel at Communications Alliance. What I thought I could do to add to this discussion is talk to you about the issue of of the conflict between nation-state control, particularly within the jurisdiction of Australia, and the international dimensions of our technology infrastructure, not just the internet, but where our technology comes from, where our information is stored, how it's managed. I can do that in three ways. I can talk to you briefly about how the Australian government, in its recent tranche of legislation, has been trying to assert a kind of nation-state control over our IT, even though we have this internationalisation of our systems and our information. I can talk to you about it in the context of the framework and the sorts of questions we get at Baker's from time to time about, well, if we do this, how can they enforce the law, or how do I enforce the law offshore, and just give you a quick view of how that seems to come out when you're forced to give advice about it. And the third thing I can do is I can say something about Australia's cyber ambassador, Tobias Feakin, who we have, and who was appointed not so long ago with a mission at a function in Telstra, appointed by Julie Bishop. Tobias is the ex-head of ASPI, the Strategic Policy Institute in Canberra, and he has been busy for a year. In fact, I found on his website an update as to the activities he's doing. So that's what I propose to do. So first thing, what's the Australian government been doing to try to assert control over the international footprint of our information society? So the most obvious and the earliest one, I think, is that our Privacy Act says that if you collect information from somebody in Australia, personal information, then and you do that while carrying on business from offshore, you're deemed to be carrying on business in Australia. So when most lawyers saw that provision in the 2012 amendments to the Privacy Act, they went, that's not really the traditional meaning of carrying on business. But it's really quite a practical thing, because we have a lot of websites and a lot of portals that are selling into Australia. They're located in Singapore, a lot of them, or somewhere else. They use they detect the source of the inquiry on the web, they recharacterise themselves as an Australian site, and they present Australian privacy compliant notices to people using their information, and they endeavour to comply with the obligations under our Privacy Act. Now, question asked, why do they do that? They generally just do it for good standing in the jurisdiction. They don't want the regulator writing to them rude letters. They don't want their brand to be a non-compliant brand, and they don't want to have to bring their own infrastructure onshore, so they play ball. So that's one way. The government has just asserted jurisdiction offshore, and commercial organisations sort of comply with it. Perhaps the one following that, and there's probably more, but one that I had to look at was the Security of Critical Infrastructure framework. Now, this followed on a re-regulation of the telecommunications sector, which is in similar terms, but it has broader applications. I'll talk about that. So what the Security of Critical Infrastructure framework does, this law was passed earlier this year, it requires anybody who's secretly tapped by the government as being critical infrastructure to file two reports. One report is about the operator, and the other report is about the owner. And the operator report has to say what are your critical systems and who's running them. And the purpose of that information report is so that the government can assess whether your critical infrastructure is vulnerable to attack by a foreign entity. The other thing you have to do is you have to say who owns you, including who owns a percentage of a percentage of a percentage of you, all the way back to the nation-state ownership of that entity. So you file these two reports, you wait. If the government doesn't like what it sees, the minister has a power to direct you to change your arrangements. And in particular, in the regulatory impact statement with that bill, the government can gives the example of a low-cost information service provider who might be supporting something like a water system or an electricity supplier or somebody critical infrastructure-wise offshore. And they see that as a vulnerability. They'll direct the operator to cancel that contract and find somebody they consider more secure. So that's another way of trying to control the internationalisation of information by being able to point to. Now, the telcos were subject to that through an amendment which became law on the 18th of September last year, similar sort of framework. The minister, if you make any change to your network or facilities which could be adverse to the security of your infrastructure, security under the ASIO Act, which means protection from espionage, camouflage and interference by a foreign government, amongst other things, then you can be directed by the minister to change what you are planning to do. So that's one approach, security of critical infrastructure. The next thing that happened earlier this year was we got the Foreign Influence Transparency Scheme. And what that says is that if you are acting for somebody who's a foreign government or a foreign government-related entity, you have to register. So this is quite interesting. The foreign government is defined to be the actual foreign government or a part of a foreign government or a political organisation associated with the foreign country, and they own sovereign wealth funds, so they're quite active in our economy, and they own some banks or have a large share in the banks. The test is that you have to own 15% of one to be a related entity of one of these foreign principals, and if you're a related entity. If your related entity owns 15% of something, then it makes that a related entity, which makes that a related entity. Now, these entities don't have to register, but if they knock on your door and say, please write a paper to go to Canberra and lobby for a change in the law, or please make a donation to this university for a facility, or please communicate a message, then you have to register as acting on behalf of the foreign entity. Big change to the law. There's an exception for legal advice, fortunately, but it only goes to legal advice. So all those times where you've actually done some advocacy on behalf of your client on a public forum would probably require even a law firm to be registered. A very interesting way to try to expose the influence from offshore. So that's number two. Number three, the Assistance and Access Bill. So many of you might have heard about this. This is the government expanding its ability to get access to over-the-top information. So our starting point before this legislation came into law was that if the government wanted to intercept your message, it had to get a warrant from a judge. And it delivered it to a telco, and the telco, who's obliged by their regulatory scheme to have an interception plan, would go to their interception department and they'd hand it over, they'd get your communications according to the warrant, and they'd give them to the police or the National Security Agency. So that's the existing regime. The other part of the existing regime is the one that was just alluded to, the Metadata Regime. Under that, any service provider providing communication services must keep 2 years of your metadata, including your account, your service, who you spoke to, how long you spoke to them, where you were when you did it. That's all lined up. Fabulous data set. They get 2 years of that. They put it in some analytics. They get a picture of who you know and where you were, and it's absolutely rock hard because it's not interpretive. It doesn't come from what you said on the phone or what you might have been trying to hide. It's actually what happened. So very powerful tool, but they can get that on a notice. They can just write notice, ask for it, it gets handed over, and a lot of agencies can get access to that. So that's our existing regime. And the government decided that the metadata is only being kept by telcos and carrier service providers, so it's created a third class called the designated communications provider, and the designated communications provider includes just about anybody who touches a communications facility. So the carriers and the carrier service providers are the people you buy your SIM card from or who facilitate communications. But a designated communications provider goes as wide as the provider of an electronic service, so anybody with a website. the manufacturer of a equipment or a component, a software company that writes software, a company which provides a service that updates software or facilitates it, the owner of a facility, all those guys. So these guys are now designated communications providers, and the government can issue 3 new orders to them on its own volition without actually going to a judge. And they are a request. And if you get a request, you negotiate, you get paid if you want to comply. Or 2 notices, one that can require you to remove electronic protection from a system, to install equipment, to install software, to disclose information, can require you to cover up what's just been done, and the third, which can make you build a new capability. So those notices aren't allowed to facilitate the delivery of information. The framework is supposed to require a warrant still if information's handed over. It's just supposed to be to facilitate access. But myself and others are wondering how, if you get equipment installed on your device which shares information, that a warrant would still be required. It looks like it wouldn't, so it looks like very powerful legislation. So what's the international dimension of this? Well, designated communications providers is defined as wide as possible in the Act. It includes foreign corporations, and it includes anybody that provides a service with an Australian customer, just one, and anybody who makes a component or device which is intended to be supplied to Australia. So you're looking at that and going, wow, that's very aggressive. But then puzzle me this, how would you enforce that, right? There are all these machine shops in China which have suddenly been made designated communications providers because they're making components for equipment which be supplied into Australia. But how, if they got a notice from the Australian government, could they possibly comply? And the answer to that is they probably won't. And the notices probably won't be issued. But the government is taking a view, a bit like under the Privacy Act, that, well, we might have some big brands who would rather cooperate than fight, and they'd rather have the notice directed at the target who's actually got the information. But it's not a very satisfactory arrangement. That the law seems to go much wider than it can possibly go. And the most recent one that you might all be interested in, the one that happened yesterday, yesterday morning, the amendment to the criminal code for the protection from abhorrent violent content. So what the government's done here is it's inserted a provision in the criminal code which says that if you're a host of content or a deliverer of content and you make violent abhorrent content accessible, which is content filmed by the perpetrator or their accomplices in relation to terrorism, rape, murder, torture or kidnapping, if you make that available online, then you commit an offence punishable by 10% of your global revenue unless it's expeditiously taken down. And the EM makes it clear that expeditiously taken down starts when you publish it, not from when you find out it's there. I think the way that this legislation is supposed to bind international providers, according to the EM, it only relates to delivery of the content in Australia, but it applies to anybody who is responsible for the delivery of that content in Australia. So it asserts an international jurisdiction. But the way it's supposed to work is it makes the fine so big that if you're facing it, you might take precautions just not to have to deal with that or have that come up as an issue. It's probably the largest fine I've ever seen in a piece of Australian legislation, 10% of your global revenue. So that's sort of a cook's tour of different ways the government sort of coming at these services which have an international dimension where there's an international thing. So what about the second question then that I said I'd talk about, how is this stuff enforced? Well, there's a couple of ways that enforcement sort of becomes relevant. There are a couple of mechanisms you can look for enforcement. So one is you could prosecute the foreign company in their absence. You'd get leave from the judge to serve. You prosecute in their absence. You run it to the end of the day and get the fine from the court. And then you say, where are their assets in the jurisdiction? And you take the subsidiary or anything you can find and try to try to take ownership of that and sell it in order to pay the fine. Never happened, but for some international companies, when they ask the question, how could this be enforced, that track is a line. The second way things can be enforced is people could be extradited from other places where there are extradition treaties, and in particular with the Interactive Gambling Act, which has a big problem with international enforcement, the provision of overseas casino services into Australia. The threat is that if you're a director or officer of a casino that's providing unlawful gaming services to Australians, then when you get to the border, you'll be on a blacklist and you could be arrested. No holidays in Australia. That's the enforcement mechanism. So that's actually a live and real mechanism of enforcement. The other mechanism of enforcement is the MLAT procedure, the mutual assistance, the mutual legal assistance treaty procedure. So there are a lot of countries who sign up to that. What you do there is you go to the police force of the foreign country and you say, we need to get these guys, they're doing damage in Australia. But there are some conditions there. There's a relatively narrow range of offences, and the offences need to be also offences in the jurisdiction where they're taking place. And the police force need to cooperate with you. Now, I understand that there's actually quite some informal cooperation between police forces about things like that, but that's a way that you might get at somebody who was committing an offence in the place where the offence was happening. Consider, for example, though, you couldn't do that in the US under the abhorrent violent conduct legislation because they've got a constitution that says they have a right of free speech. And their law goes exactly the opposite direction, that you're protected from liability if you're a host or a content provider. So if you turned up and said, please arrest the directors of Facebook for breaching our abhorrent content law, the US authorities would say no, that would be unconstitutional. So that's another mechanism which exists. And just one other that's kind of relevant is that the US has a thing called the Cloud Act. And the Cloud Act is designed to improve cross-border sharing of information by regulators, and it's only relatively new in the US. And what it contemplates is that countries that want to get access to digital information from the US for law enforcement purposes should sign up to a treaty with the US, and then there are conditions in the Cloud Act as to what that treaty, who these countries might be. And to sign up to one of these treaties, you need to be a kind of first world democracy with a lot of civil rights, because they want you to have a comparable civil rights framework. So one of the points that we were making in some lobbying and discussions on the Assistance and Access Act was that in fact these aggressive powers issued by departments, not judges in Australia, are actually contrary to the provisions of the Cloud Act and would probably prevent us, or may arguably prevent us, from being a co-signatory to that. But that's also a mechanism that's on the cards to help share cross-border information. The important cross-border enforcement mechanism I didn't mention was that you can enforce some civil orders. There is another treaty for enforcement of civil orders across borders, but we're not talking about those. We're talking about state-based penalties. And as a starting point, one state doesn't enforce the penalties of another state. So that's my second point. So my third point about Tobias Feakin and the Cyber Ambassador. So Tobias, when he became the Cyber Ambassador, went into the DFAT, and he's published a report about his activities over the last year, which you can find online, about the policy that he's implementing is called Australia's International Cyber Engagement Strategy. And when you look at what he's been doing, it's quite a lot of work with the Solomon Islands, Fiji and PNG and other places on developing their cyber infrastructure and improving international trade. He's been doing some work on the APEC privacy framework in Asia, trying to improve adoption of a coherent privacy framework in countries around Asia. But in relation to cybersecurity, particularly, it's a relatively limited list. He's been working with the Australian Cybersecurity Centre to develop new contacts with international counterparts to protect Australian citizens, businesses and the government online. He's been establishing working with people in Fiji to establish a national computer emergency response team. and providing technical help to Samoa, and he's been working on cooperation with ASPI and others to build an understanding on cybersecurity with the Indonesian government. So those are all good things, but when I last saw Tobias at ASPI, he was working on something called Cybersecurity Norms, and he was trying to come up with a list of some broad principles that just about any country could agree to as good citizen behaviour in relation to protection of fellow citizens of the world in cybersecurity. And I'm not seeing, sadly that seems to be lost in between the ASPI working party and his appointment as a cyber ambassador. And I think that it is amazingly frustrating to see the degree to which scams and online phishing attacks and even some nation-state phishing attacks are the source of our data breaches in Australia and are targeted at Australian citizens. And yet, there doesn't seem to be any activity internationally targeted on stamping that out, or at least it's not on the list of our cyber ambassador. I'm sure there is some activity, but it's not on that list. It's remarkable the extent to which we are exposed to operations in other parts of the world that target and are very successful in taking information from our citizens. And in particular, if you look at the Office of the Australian Information Commissioner's reports on mandatory data breach reporting, it's a very consistent stat. Last quarter it was 54%. It's always 52, 54, 55 malicious attacks from cyber criminals as the cause of the breach. Roughly 30% is human error, but the more than half consistently our exposure to crims in the international economy attacking the infrastructure in Australia. So those are my comments. Thanks, Mark. Thanks, everyone.
Thank you, Patrick. So I just wanted to sort of continue the theme on and possibly pull a few aspects of it a bit together. If we consider where we're at in terms of the cyberspace, what we've got is we've got an environment where we've got a number of stakeholders. Of course, we've got the governments, we've got the companies providing application services, we've got the companies that are providing the infrastructure and the communication linkages to the customers, and we've got the customers. And then we have to expand that dimension to consider that what we've now got is we've got all of this happening in multi-dimensions around the world. And so we might be dealing with customers in another country, we might be dealing with companies from another country. The people that are operating networks might be from another country. And so you've got this situation where the dynamic of this cyber is that it is something that is spread around the world. However, it is impacted upon by the local conditions, the local government, local way of doing things, the local laws and legislation. Now, in Australia, over the last couple of years, we've seen a number of pieces of legislation that have tried to identify and, if you like, plug holes in the way that the government is dealing with cyber. So we've seen legislation regarding metadata, data breach, abhorrent violent content, and a range of other pieces of legislation that have been put through. Looking at it, though, you could argue that it's a bit like a puzzle that's got many missing pieces, and that it's very ad hoc. And in regards to the most recent piece of legislation that was put through, you could say that it was nothing more than an election stunt. And really, cyber and telecommunications is something that's the last thing that we need. What we need is a concerted way of looking at things and thinking them through. Now, if you look at the courts, particularly in Australia, one of the things that's evolved over the last 50 years is that it's almost a mandatory aspect of all courts today, in particular in regards to non-violent and criminal law, that there is mediation, in particular in commercial law and other aspects of the law. Mediation is a an accepted, reasonable step that we undertake in our dealings with other parties and with the courts. The situation that we have at the moment playing out around the world is that for various reasons that have been put forward, we have a situation where a couple of countries, including Australia, have taken action against a multinational from China. We have at a state level, there are disagreements occurring with China. And of course there have been similar disagreements with other countries such as Russia, Iran, North Korea, and so on. The issue is that what we're seeing, in particular with the situation with China, is that the issues that are occurring at a state level are moving down the silo, if you like, to actions against multinationals or actions against companies. Now, whilst that has been something that we have seen in the past, it's not unique to this situation. What is difficult, of course, is the impact that this is having on global telecommunications, global use of the internet, and the potential to drive us towards a situation where we have separate internets and regional-based internets or power-based internets. And a number of people are talking about that this may occur quite rapidly over the next few years to where we have this scenario playing out where 10 years from now the internet will be completely segmented based upon power bases in the world. Now personally, I don't think this is a very good idea. I would like to see that the principle of cyber diplomacy or mediation be expanded. The United Nations does have or has considered this concept of cyber diplomacy. I don't think they've actually considered it in this particular scenario. We've sort of seen this occur very quickly in a way that a lot of people didn't really see the impact that it would have. And so what we've seen in Australia is one where the company or companies that are affected, Huawei, ZTE, have no recourse other than to go to the courts and to rely upon finding some loophole in the local legislation or in the constitution of that nation that would give them relief from the action that's been taken against them. It would be preferable from my perspective, similar to what we have in terms of trade with the World Trade Organization. You could argue that this is also a matter of trade in that companies are not being able to trade as they would expect to be able to trade. However, the WTO really would just look at this and go, wow, this is different from anything we've dealt with before. So there's a need, if you like, for the United Nations to ramp up a cyber diplomacy capability to provide a framework where multinationals that are impacted upon in some way are able to negotiate with those countries that are taking action to find a resolution to the problem. Now, if we look at the current situation with Huawei, ZTE and other Chinese companies that are being impacted upon, they might be able to seek relief by arguing that the actions are in some way harmful to to their operation in the world, or operation of the global internet, or operation of the way that relationships are occurring around the world. There might also be a way for the evidence that's being put forward for these actions to be contested. Currently, the Australian government has relied upon a specific mechanism, and that is the argument that the multinational may be told by the host country to take some action in the future that is detrimental to the country, to Australia. So the argument in the legislation is that one or more of these companies might be told by the host government, in this case China, to take some action that might be detrimental in Australia to the people, the government, or some other organisation in Australia. And it's future-based, which means that it becomes very difficult for that company to find relief, because the argument is that, well, if there have been no examples of this to now, arguing that it may happen in the future gives us no relief or no way to argue that, that this wouldn't happen. In particular because most multinationals operate through subsidiary companies, and those subsidiary companies have their own boards, they have their own governance mechanism, they're required to operate under the legislation of the country in which the subsidiary resides. And so the board of Huawei Australia, for example, has been very straightforward in arguing that Huawei Australia would not condone or permit any action that would be taken such that it was detrimental to any of their clients, in Australia, in breach of Australian law. So, however, the government is simply overriding that by saying, well, we don't believe that the board has control, that Huawei Australia has control over anything, that the Chinese government, through Huawei in China, would tell people in China to do something, and that would miraculously happen in Australia. Now, there's been no evidence as to how that would happen, and there's been no examples of how that would happen, but this contention has been made. And the problem that we have in this particular scenario is that multinationals or people trying to do trade have no way to argue one way or another. They're stuck in a hole, if you like, because every argument they may put forward is being overridden. So I think the point that I'm circling around is that there really needs to be another mechanism, one that is United Nations based, or through a separate organisation, or possibly something that the World Trade Organisation takes up. However, it would need a major expansion of what it does if it was going to take into account what's happened so far with China and potentially what might happen in the future, unless there's a resolution to the current issues, because this could potentially get a lot worse than where we are now, and I think that that's a key aspect of this. I think the other point is that I'd like to make, and I suppose there are two other points. The first one is that there's an element of duplicity here, because it doesn't take a government of a country to tell a multinational to do something against another country's best interests for it to occur. Most of the equipment that's used in Australian telecommunications is made in China. So you then have this situation where this equipment, which is all made within a few kilometres of each other, some of it's banned, and yet some of it's not banned, simply because there's an argument that the companies that have this equipment made in China by Chinese companies in Chinese factories, that this equipment in some way is not tainted. And yet there's no evidence that the equipment's not tainted or hasn't been tampered with in some way. Now, of course, the engineering argument then follows, which I've personally been asking for 12 years now, and almost 13 years, I looked it up the other day, is that I've been arguing that we need to have a telecommunications security assurance centre or capability in Australia, where we look at telecommunications equipment throughout the life of the equipment, not just in the supply chain phase, which is what's happening in the UK, where Huawei is voluntarily providing their equipment and software to be looked at before it's put into operation. And of course, that's been an insightful process. And interestingly enough, Huawei is actually paying for that process to occur in the UK, voluntarily paying for it to occur. But my argument has been for 13 years that Australia especially needs its own capability to look at the equipment from all vendors, irrespective of wherever it's made, because you don't have to have seen too many movies nowadays to realise that it's not hard to tamper with equipment in such a way that you've made that equipment subservient to your demands or needs. And of course, this can occur during the supply chain phase, it can occur in operation, and that can occur through either software tampering or hardware tampering with those devices. It is very easy today to actually tamper with equipment, to tamper with the hardware in equipment. And so for 13 years, nearly 13 years, I've been asking for this capability to be developed. And I'm hopeful that this is going to happen over the next couple of years, because I find legislation that ultimately leads to a negative scenario, which is that companies or multinationals are banned, is really symptomatic that there are two other problems happening. One is that there's a problem happening at a state level, which should be resolved, in my view, at a state level. And the other problem is that there's no effort being made to actually look for what you would call auditing or governance of that entire ecosystem. And so what we're seeing is that there's a lack of real auditing, a lack of real evidence, and, if you like, a lack of governance in this particular case within the telecommunications industry. And so I'd like to end my point there and to provide the opportunity for anyone that might like to get involved to ask questions. And so Laurie's got the microphone. I'll let Laurie pass it around.
And because Laurie has the microphone, Laurie's going to just make a quick comment because I've just received an email that I think is relevant. When I worked for Internet Australia, we had dealings with the Parliamentary Joint Select Committee on Intelligence and Security in relation to the Data Retention Act, which we described at the time as fundamentally flawed, and it remains so. One of the things we managed to achieve in our negotiations was a review after 3 years, and it's just been announced that, or it's being re-announced, I think, that submissions are now welcome until the 1st of July. So, Patrick, on your bike, son. We've all got something to do, yeah. So that was really a comment. But if anyone wants to comment further on it, go for your life.
Well, I was going to say that just as I'll say the thing I was thinking of first, Mark's comment. I mean, one of the there was a forum on the Assistance and Access Bill last Wednesday where we had the CEO of Senitas, who's Australia's sort of largest developer of encryption-based tools, and the CEO stood up and said, "We're losing work from our foreign customers because they don't want their encryption systems built in a country where the government can, on their own volition, just turn up and ask for the code." And that really struck a point with me because I've had some questions from clients saying, well, we're just about to upgrade our key management system for this data centre. Should we install it in Australia? Because we're worried that it might be compromised or it might be accessed. And so I did this review, and the argument by the supplier was that this was a much tighter, stronger, more resistant key system, which would ensure that the customers had to be asked if their information was going to be accessed. So I said, well, if you're really sure the code's safe, then maybe it should be installed, and that would be a better framework to have in this jurisdiction than one that's looser. But once the government starts to get access to what everyone's developing here, we do have a real trade issue as to that. It resonates with the reports that the WannaCry virus, involved elements that were built in the NSA, and are we going to find that other things are being compromised because of government access? It's a serious concern. In relation to the metadata scheme, I mean, there are two big problems with that scheme from my point of view, which maybe don't go to the sort of civil rights focus we're talking about. But one is that you're subject to it the minute you become a carriage service provider. So if you're, I had this, you have a big data centre or a big IT service provider, and a bank says to them, oh, we'd like you to do the network for our branches in area X. And you being a good supplier, you go, yeah, we'll resell you that. Well, the minute you resell the capacity, you become a carriage service provider, and the minute you become a carriage service provider, you've got mandatory data retentions on all your messaging systems. And all your, we said to the government, look, no, it needs to be more iterative than that. You need to say that it's about the carriage, it's not about the system. But no, they've wedded the obligation on the actual being a carriage service provider, and it catches any messaging system you run, which is complete madness. The other thing is that it's hooked to the definition of communication in the Interception Act, and the definition of communication, which is the thing you intercept or you store information about, is extremely broad. It includes signalling, it includes data, it includes all sorts of stuff. But the Interception and Access Act is written as if it only includes listening in on people's analogue phone calls. And so literally read, this legislation requires you to keep metadata on a whole lot of signalling that's happening between IoT devices, and sessions that are being set up in networks where there's actually no possibility of usable data, and it's just madness as a regulatory payload for the industry that the government hasn't thought more carefully and considered more carefully what is actually needed. I'm not of the camp that says that all surveillance by government is an invasion of privacy. I think that there's a story about if you put a picture of somebody watching on a bus stop, the bus stop doesn't get vandalised, and people lift their behaviour when they know they're accountable, when they know they're on the record, and when they're being watched. It's not, and the government is thinking, do I come up with some hugely controlling penalty regime, or do I just create some transparency? So if you're in the government and you're trying to do that, transparency on the right terms with the right controls and the right governance is actually a positive thing. So, and I'm not coming from the, it's all bad framework, but at least they need to limit it to what's really required and keep it down to information that is going to serve some useful purpose and not be a payload for industry.
Thank you. Oh, sorry, later. Sorry, Jenny Masters from IBM. Thank you very much. Really insightful. A little depressing, to be honest. A couple of things. Mark, you mentioned that you've been asking. Who have you been asking? And I've got another one.
I've been communicating verbally with literally everyone that I can talk to, and I'm the only person in Australia that's focused on this. However, I think it was last year. I think it was sort of the middle of last year. I figured that what I would do is to expand that to writing, and I wrote to the Prime Minister and the Communications Minister and the opposition, head of the opposition, and sort of everyone. And it was all in one letter, and that letter is now online on a newspaper's website. And the response is also online, and the response is one which says two things, or sort of to me it says two things. One is that there's no problem, and the other one is that if there is a problem, the problem is the telecommunication industry's problem.
Second question's around the Huawei issue. It's been big news for a long time. The CFO is still in custody. Yet I'm hearing there's no evidence, and yet the NSA has evidence. I'm just wondering, is there something, who's not telling what?
So let me just talk about what we do know. So what we do know is that there's sort of a couple of different issues in here. The first one is that there is an argument that's been put that the CFO of Huawei signed off on financial transactions related to the sale of equipment to Iran that was in breach of a United Nations sanction. So in the sense that for the purposes of our discussion, that's sort of a bit outside sort of what we're talking about. The sort of what we're sort of talking about is the issue in regards to the Chinese legislation that was put in about a year ago, which states that companies, organisations, individuals are to, on request, are to take action to support the nation's security, espionage and all the rest of it type thing. Meaning that the government at any time could tell anyone to do anything in regards to taking actions to protect or secure or to carry out espionage and so forth. And this is in black and white. And so this legislation is what was the, if you like, the vehicle for the Australian legislation that said any company that is hosted, you know, or the home country has legislation like the Chinese legislation, that company's banned. Now, if you look closely, the United States has very similar legislation, but quite remarkably, no American company's been banned, right? But interestingly enough, they probably wouldn't be banned in this case because no American company makes telecom equipment that, you know, well, to Australia even, except of course for Cisco, right? So you have this quite interesting scenario. Now, in terms of evidence, the only evidence that we have in the public domain in relation to nation states telling companies or forcing companies to participate in espionage is through the Snowden papers, and that is that the NSA were forcing Cisco and Juniper to provide backdoors into their equipment around the world so that the NSA could spy on anyone and everyone. And so there was, you know, thousands of documents documenting the programs and how this espionage was working and all the rest of it. And the only other instance that we have of evidence, of course, is that the laws in regards to who can spy on what. For example, the FBI is internal in the US, right? The CIA is external, right? So the CIA is not allowed to take action or spy on Americans within the United States. So what the CIA does is they ask the Australian ASD to spy on Americans in America, right? And we provide them with the information. And they spy on Australians in Australia and provide the information the other way, right? So that was one of the rationales for groups like the Five Eyes, was it wasn't just for spying on other countries and other groups, it was also on spying on each other and within the organisations. Now, in terms of Huawei and ZTE, there is no public evidence. And the more that this has gone on, the longer this has gone on, there has been more and more come out that there actually is no evidence. Even evidence that the NSA has claimed exists, it now appears that this evidence actually doesn't exist. And so, because they've been put under a lot of pressure to come up with evidence or even times, dates or general something, but there's nothing.
You can take it away. Thanks very much. I really enjoyed Tim Unwin, a lot of insight. And I was quite involved until a couple of years ago in negotiations on behalf of the British government with actually Australia and Canada and US and Europe. So my information isn't completely up to date. But one sort of challenge is I actually think Australia is more involved in some of those international discussions than may have come across in your presentations. And I know there have been some very interesting discussions around what you've been talking about. But your conversations raise two issues I think that I've struggled with for a long time and I don't have an answer. The first is the desperate need, and so the first presentation you highlighted all the reasons why, but the desperate need for us to work together collaboratively internationally, because we're in danger of getting knee-jerk reactions by this government, that government, and the other government, particularly for sort of things which we've known have been going on for Facebook for years. Okay, they haven't been dealt with, but they become political priorities. So we do need to have those international negotiations. How to do it is a question I have for you, because we haven't been very successful at it. The second aspect of that is there are, and I don't know how many people here are familiar, a number of ongoing international arrangements to try and enable, the most connected, least protected country is the biggest threat. Now, really interestingly, that hasn't proved to be the case. So, an island like Mauritius isn't actually the world's biggest hacking base. But it will be sooner or later, because that's going to happen. So we do need to build capacity in the countries, and you mentioned Samoa and Fiji and the interesting things. But there are, there's the Cybersecurity Unit at Oxford, which is about cybersecurity capacity development. There's collaborative work between the US, Australia, New Zealand, UK around building this capacity. We're not doing it fast enough, and we don't have the legal agreements in place between countries. I think the EU is doing some great stuff. So I'd just, if you could say something about those. And on China, thank you for saying that the US, is doing it anyway, and this is a political issue against Huawei because of commercial reasons. That having been said, how do I phrase this politely? But the Chinese government has access to everything that is on WeChat, which concerns me a little bit, but hey, everyone's got access to everything. So I have many friends at Huawei, and I like to believe them. And you're absolutely right in saying there is no real evidence there, but that may be because we haven't been looking quite hard enough.
Well, a couple of things occur to me. One is that if you read up, as I've been doing, on how Trump got elected president of the US and the Russian attack on the US election, one of the reasons the national security agencies say that they didn't jump when they saw it was normal, and we do that to them. That was the rationale. So, the quid pro quo part of, the dilemma here is a real factor. The other thing that's quite interesting, I think, is that if you look into the security critical infrastructure legislation, there's some guidance, at least it was in the draft, I can't remember seeing it in the final act, which says that being subject to a legal regime in your country of origin does not mean that you're controlled by the principal. I think it might be in the Foreign Influence Transparency Scheme. It's in the foreign, it's the latter, not the former. So that's quite an interesting thing, because there's a distinction between a foreign principal who is the entity and is part of the entity and owns part of the entity, but actually being subject to the laws of the country doesn't qualify you. But for all the reasons we've been discussing, that would seem to be a pretty relevant factor, right? And I'm not sure, Mark. I'd be interested to know where the act is that says that you can ban an organisation if their country of origin has that directive surveillance power in their legislation. As far as I know, the determinations about Huawei have been discretionary determinations made in the case of NBN by the minister controlling the organisation, and in the case of the pronouncements about 5G, for example, I think it was just a policy announcement. They have power under the Telco Act, under the Telecommunications Security Sector regulatory regime, to make orders. But they didn't make the orders. They just told people that if this equipment was bought, they would make the orders. Now, under that regime, in order to actually make the order, the precursor is that ASIO has to make an adverse security assessment. And when the minister's got that, he can make the order. But the regime is set up with a lot of soft power, so the government can warn you that it might make the order, and then the government can meet you and say it's thinking of making the order. Then they can negotiate with you about making the order. But only then, when they actually want to make it, do they have to get the adverse security assessment. So we have a lot of, I don't think we have anything as plain as that, that there is a, if your country has that law, then we can ban your
Yeah, I would need to check, and it's hard sometimes to remember. It may be that there was a regulation put out by the Minister's office, but it clearly states, the delineation in terms of how an order would be made. That if a company is, susceptible to an order from a foreign government, that it would be the Minister could make an order banning the use of that equipment. So it might have been a regulation that came out of the Minister's office rather than an amendment to the legislation. I suppose the getting on to the important part of it in terms of the future, if we see all the sort of the knee-jerk reactions that have been going on for the last sort of 6 years in a range of different aspects of the digital world, the only real approach that is sensible is for the United Nations to ramp this up. So we have the WTO, and we have Interpol, and we have other organisations. We really do need to ramp up an organisation that is going to be able to look at cyber diplomacy and issues regarding cyber, because Zuckerberg came out and said, please regulate us, right?
There's a real challenge. I don't disagree with you. But there are certain governments that won't actually allow the UN to do that.
But that's true of every aspect of what the United Nations does, if you know what I mean. Like, not everyone has signed up to the WTO. Not everyone has signed up to the treaties that the United Nations puts out there. But if you don't start, what I'm saying is if you don't start somewhere, then you get a situation where a country like the United States tells Australia to jump, and Australia just simply says, we'll get a gold medal here, we'll jump as high as you like. Now, in regards to ASD and the current head of the ASD, Mike Burgess, he's made a number of statements in the media indicating that there is evidence that there's clear evidence of Huawei being involved in actions that they shouldn't have been involved with. And yet every time I've emailed or asked for Mike Burgess to produce any evidence, it's just silence. Now, ASD, unfortunately, has a history, as we all know from WMD, right? And, the now Member of Parliament, Andrew Wilkie, who walked out of the organisation, the ASD-ASIO block, because they were fabricating evidence. And they were putting forward advice to ministers that was fantasy. Right? Now, we know this as fact because people have come out subsequently and backed Wilkie's, recollection of events. And I'm seeing the same thing happening again now, because they're making statements publicly and they are putting forward evidence to Parliament, which has no basis of fact. That can be traced either within Australia or externally or by anyone that I see digging into this around the world. And a lot of people are trying to find this evidence, right? And so therefore, it's time, in my view, that ASIO-ASD actually come up with some facts, because otherwise they're going to lose all credibility. And this is about trust as well. And currently the trust of ASIO and ASD is plummeting. And for Australia, those organisations have been the mainstay of security for the nation for 100 years. But trust in those organisations went down with weapons of mass destruction, and it's plummeting now.
Thank you for your presentations, really interesting. My name is Rachel Fisher. I'm from South Africa, so I specialise in information ethics. I just want to hear your stance on corporate social responsibility in this case, because a lot of what has been discussed, of course, in line of the industry session, call it maybe governmental legalese, or it's very high on a macro level. And in the end, we are still working within societies, within countries that have citizens that do not understand these interactions, the legal documents. So your stance just on CSR?
Well, I'm probably the dissenter here, but I think corporate social responsibility is a political correct fiction. Okay? Corporations are in business to make money, and they will do whatever it takes to make money. And if it means they have some social conscience, then they'll do that. If you can convince them it's in their interest and they will make money with it, then they will. But I don't think it's anything more than that. I don't know if that's the answer you wanted, but that's the way I see it.
Your own approach? How do you see your own responsibility in terms of informing the public, those that don't have access to these events? Because, I mean, this is already very elitist, isn't it?
Yes, yes. Well, I'm formerly a professor, so my approach was to tell all my kids everything I could about security so that they could make an informed judgment, not to indoctrinate them, but to give them the facts and let them draw their own conclusions, because that's the right way to do it. I could be a propagandist and say this and this and that, but I never did that. So my point of view is to present all the facts and let people make their own assessment and decide for themselves. There are plenty of propagandists out there. Okay? They're everywhere.
Patrick. Thank you for your question. It reminds me of an exchange I had with somebody from the AI part of Microsoft. And, forgive me for the diversion, but one of my favourite parts of the new Blade Runner movie is that Joy is the ultimate AI, and she's there to help you. And there's a subplot that's running that the protagonist destroys her connection to the net so that she works for him. And in the context of AI and its increasing functionality, there's a big threat to ordinary users in the sort of in the online environment is that you're up against someone who remembers more about you than you do, who knows more about your friends than you can know, and can decide things more quickly than you can. There's also learning human psychology in a way that can be quite manipulative. So my question to the AI expert was, how is this going to be moderated and controlled? And the answer was, well, if our customers don't trust our service, we won't have any customers. And it's got to be about building trust in the relationship you have with your customers. And that in some ways that's the strongest, I think that, what he was saying is that's the strongest moderator of corporate behaviour and ethics. So I don't entirely buy that. I think that things can be more subtle and more complicated than the customer can know, and that trust can also be managed and manipulated. So I do think we've got a real issue in that space. But in my experience, companies are made of people, and people generally act in bad faith, generally do not act in bad faith. We have lots of parts of our law where officers and officials engaged in unlawful conduct or are personally liable, and nobody I've ever met in legal practice in the city would actually give an advice which told somebody to act contrary to the law or in a way which was damaging to another individual. So I think that I think that it's a really important question, and you have to we have to watch how it goes. But and there'll need to be an element of regulation. But the overall driver is about the market and how it's running. Can I just also add an answer? The questioner before sort of commented about how do we bring different markets into alignment, right? And it's interesting. It's sort of like there's a bit of a competition of ideas, because you last week or maybe the week before, the federal government announced that it was upping all the penalties in the privacy regime, and there were going to be new huge penalties for breach of privacy. And I looked at that and I thought that's very funny, because I think the last time I saw a penalty against somebody for breach of privacy was 2012 or sometime a while ago. The Commission doesn't generally do it, but at the bottom of the press release it said, and also the government is going to be looking to make social media organisations obtain express consent for the sharing and use of personal information in their platforms. And I'm looking at that and going, well, that should have been the top line release, because that's bringing Australia into line with the GDPR, and it's looking at some of the issues that are being discussed publicly and responding in the same way as Europe. So it might, it would be great if our politicians had the time and resources to get together and negotiate coherent frameworks at the front of the line, but at least if we're paying attention, we can slowly evolve our frameworks to address the sort of questions with common solutions.
It's probably at this time that I should just recount my my frequent dream. I wake up and I've had a dream, and I've sent, you can choose whichever telco phone manufacturer you like, and I've sent them an email, and it said, "Dear so-and-so, please find my mucked up copy of your services agreement with my suggested amendments." You can imagine what response I dream I get.
Yes. So I'd like to go back to the previous question a bit there. I believe that there are certain inherent outcomes that you want to achieve, particularly in a country like Australia. We were one of the first countries that drove tariffs down to the ground, right? Not in every area, but in many areas. And we were one of the first countries that opened our doors to foreign investment and interaction with other nations, with businesses and other nations, with individuals. And so, if you like, Australia tried to adopt an open, fair, and competitive market, whichever market it was. We were trying to ensure that there was an opportunity for competition, for open and fair access, and to bring the best of the world here, but also to drive Australians and Australian business to achieving the best outcomes that they could. What I see in what's happened with Huawei over the past 6 years is that there's been a dramatic winding back, because of course there are consequential outcomes from a business point of view. If you're looking at the industry and the governance of that industry, how does Comms Alliance now take into account a particular standard for a system or telecommunications, or how does Comms Alliance account for this within the scenario that at any particular point in time some of the people participating may be banned? And what happens when there's a discussion on 5G? Is the Huawei person locked out of the room? And so how does the governance of the market within Australia occur? Now, also from a business-to-business point of view, if you start banning companies, then of course the other companies are going to raise their prices. And you're also going to get a slower time to market. In terms of from a consumer's point of view, they're going to get whatever it was, whichever widget, they're going to get it slower because there's less companies providing it. And in the world, it's the nature of the world that there tends to be enough companies to provide what the world wants. You know, there's not like 10 extra companies or only one company. There tends to be enough to satisfy. So if you start banning companies, then there's a ripple effect. And we're already seeing that now with companies that are having to delay their 5G because of the Huawei ban in Australia. And so that has a ripple effect in terms of how do these companies, do their business? How is the governance of those companies interacted with? How are their consumers impacted by what's happening? And so there's an uncertainty that occurs. And to me, uncertainty is counter to good governance. And so you have a problem in that respect. I would go the other way. If I had been the government, I would have argued that that companies that utilise products from company XYZ, they're to make information available electronically online, that they're to increase their governance of the use of that, those equipments or systems, that they're to increase their auditing. And that goes back to my request for a telecommunications security assurance centre is that you're increasing your auditing, you're increasing the visibility, and that visibility works its way up the chain. And so the boards of the companies are able to get more information about what's going on, and the customers are, and then the government is. And so I believe that if you look at the example of what's happened at Huawei, is that we're actually going counter to good governance and also counter to good business practices. And so for a country like Australia, and it's different around the world, Australia relies upon a low tariff open environment for its existence, really. And if we get away from that, then we're creating problems for ourselves. And the ripple effects is that Australia will fall behind.
A question from me on a slight tangent, just trying to work out, I mean, are we not overstating the need for all of the security between the different companies as to what they're doing? And the evidence I give you is, with the exception that half the world drives on the right-hand side of the road and the other half drives on the left-hand side of the road, airbags, ABS braking, intermittent wipers all seem to come out in all the same cars at the same time. So are there really any serious secrets between what Huawei's products are and what someone else's products are for more than about 3 minutes?
I think the concern with 5G anyway is about software-defined networks. So, we're all used to having our iPhone updated regularly for free, and in a software-defined network, the operator will be upgrading the software, and also the networking and the routing and everything that's in the equipment is available to the service provider, who is designing the system. So there's a level of vigilance required and a level of confidence which, it may be that national security agencies that think that they can, control that for the purposes of their national security are really dreaming, because it's just at that level of complexity. So I do think we're going into a new world. The question is, are we just sort of stuck in a rivalry between the traditional nation-state alliances rather than really talking about technology? I think that's the thing that sort of comes out from it.
And in response to the technology component of that question, I think that you need to look at technology from two aspects. Of course, there's the standardisation part of technology. For example, 5G, the standards are put down by the ITU, and then they're tailored for each country that they're being utilised in by an organisation like Comms Alliance, because standards provide specifications for vendors to make equipment, but then there's always a customisation that goes on for use within a particular country because of historical whatevers and sort of legacy environments. I think the key thing is that we're seeing more and more, and it's not just in vendor equipment for infrastructure, but also in devices, handsets, tablets and all that, is the products now have a small window of opportunity where a company can argue that my product has better features than their product, right? And so that's why we see handsets come out every year, because by the next year, you know that everyone else has got what you had the year before. So you're trying to leverage the feature set. Now in infrastructure, it's no different. And in terms of the 5G infrastructure set, what we're really seeing is the features, the capability, and the cost of that infrastructure in terms of rolling it out. And the argument has been put that at the moment, Huawei's offering for 5G is better and cheaper than other companies offering. Now, you could argue that Huawei's offering is cheaper because of Chinese monetary policy at a national level. But that's a different argument. That has always been my argument, that that is something that should be addressed at a nation-to-nation level, right? The fact that China's monetary policy means that exports are cheaper than exports from comparative countries, well, that's something that needs to be addressed separately than the issue in this particular instance of Huawei, which is one company in that country. But it's a feature set issue and the timeliness of those feature sets that entice customers to buy. And telco equipment really is no different from anything else.
I lots of things follow on from that. Going back, I'm not sure I agree with you about there's lots of other companies out there. I don't think there's only one Facebook outside China. So I would hope you're not going down to actually insisting on fragmentation of those. I think Huawei has lots of advantages. China is 16% of the world's population. The USA is only 4% of the world's population. So it has that huge market internally as well where it can try things out. Huawei, of its 139,000 employees, has 80,000 classified as R&D. Now, you could question that classification, but which other global digital company is structured in that way? So I think there are, you're right, there are the sort of business side of it and that. But I want to go back to pull out from all of you your thoughts about where and how we can have some kind of global agreement. And I think part of the problem is that the debates are running in parallel in different sectors. So there's I was just going back to my memories about the Global Conference on Cyberspace. That was led by foreign ministers. Whereas, some of them were knowledgeable, but totally different set of dialogues to those that were held in the ITU or in Net Mundial or whatever. I strongly agree that we need to have some forum where that happens. When I led the Commonwealth Telecommunications Organisation, we were actually trying to get some agreements around these over the Commonwealth, but things have fragmented since then. I still think 53 countries, that kind of scale is possible to do something, although it mustn't be led by the UK, which is problematic. But I can't accept it's up to the UN to do it. The UN has been trying and has failed. I mean, look at Impact. I don't know if any of you were sort of following Impact in Malaysia and the mess of all that. It needs to have some impartial broker to try and bring these parties together, because if it doesn't, you're all implying that we're actually going to be, excuse the language, in deep shit.
But hasn't the broker just spoken? Mark Zuckerberg? I mean, in a sense, for this to work, someone has to step up and say that we need it. So what I'm saying is that the multinational companies that are going to be impacted upon more and more by this, and the other different laws that are being put out in different jurisdictions, it's time for the multinational companies to step up and to work with the United Nations, because they know that the individual countries are not going to do anything for vested reasons. So maybe business itself, working with the United Nations, can start to provide a solution.
They have been trying. Mark's actually quite astute, and this is a business decision on his behalf. It's nothing else. His company is in serious challenge, so the only reason he has stepped up to the mark is for business reasons. And I absolutely agree. It has to be multi-sector across the board, but it needs to be led by people who are committed to making it work.
I'm just sort of struggling with the change of paradigm between. I know we sort of started by talking about the commercial entities like Google and Facebook and so on, and I should disclose that my firm acts for that group, groups of companies like that, if not those specifically. I think there's a very material difference between the issues associated with national security and the right to interfere with devices and access systems for the purposes of serving the nation state's perception of either its protection of its own citizens offensively or defensively. And I know we have an offensive capability which is for a defensive purpose, I suppose. That's one sort of whole area where it's much more problematic because you're talking about, one of the things with the legislation I've been talking about, the security of critical infrastructure legislation, for example, is now that's in place, you're not going to know, right? You can't say who's been nominated as critical infrastructure, and the minister can nominate an industry without saying who. So the opportunity to talk about that when the law's being made and when it's out there is very important, because after that, it's under the radar. I think that's a whole different space to the Google, Facebook space. I respectfully disagree that we haven't had our dividends from those companies. I mean, the access to Google Search AI for free is an enormous dividend, globally. And likewise, the access to Facebook storage and sharing functionality for the analytics and the money they can make out of your data is a transaction that people engage in. So whether that's you're paying too much or too little, I suppose it depends on what you think of the level of profit being made by the companies. But in that space, you've got one set of problems, which is, do we go down the GDPR path? Is the APEC privacy framework enough? Do we need something new about surveillance capitalism and the regulation of what can be done with information? Personally, I think the privacy framework is right off target. All this stuff about disclosure of the strange menu of things that some public servant dreamt up in 1988, in our case, is really off target for, is this information being used against the interests of the user to increase a price or to change a product offering so that it disadvantages the person who's sharing or participating? We don't have any regulation focused on that. It's all permissible if we disclose. So there's certainly work to be done in that space, but it's quite a different space from the nation-state space, and it's much less problematic than the points that Mark's discussing about trying to maintain a free market and trying to allow all players to come and participate when you've got the regulatory agencies picking and choosing which companies and from which countries we're allowed to trade.
Just wrapping this up with one of the discussions in one of the earlier sessions, isn't it the case, though, that what we're now trying to do is plug gaps in the way that technology is being used or misused, which really basically comes back to the fundamental design of the internet, which is what underpins most of this. And then I draw your attention to the debate that goes on with an organisation that I was associated with, Internet Australia, and its global head, the Internet Society, which is basically run by and is inhabited by, if not the people who built the internet, but the people who now run the internet. And their view, very stridently, is that nobody should be allowed to interfere with the way their little baby operates, which then brings you back to the fundamental question of all of the things that we're talking about, whether they're about nation states, whether they're about personal security and privacy, all come back to the fact, as Tim Berners-Lee observed a week or so ago on the 30th anniversary of the internet, which he created, which is that it's dysfunctional. So are we not just simply trying to patch up something that's fundamentally dysfunctional?
I don't think so. I think it's an evolution. If you remember, there were 4 hosts in 1969. There's 3 billion hosts today. And that's evolved over the last 45 years, okay? So it takes a long time for that to get to where it is now, and it will continue to evolve as needs arise and as the circumstances change. So I don't think it's dysfunctional. I think it's the way it is, and it will continue to evolve as it has for the last many years.
I agree with that, absolutely. I think that it's amazing to see how we've come to accept things that in the early days of the internet were completely unacceptable. Trying to keep the government out of the internet back in the late 90s, there was this argument about that it's a free market and it's a new space and you've got to keep out, and that was sort of argued by the participants in the industry to help it grow and to stop the vested interests who were trying to keep it back from interfering. And there were a number of vested interests who saw quite some value in trying to slow down the access to the internet by imposing regulatory regimes. But the things that were the Internet Industry Association and ISOC were fighting for back then, a lot of that's been conceded. First we had blocking all the sites that are on the Interpol list to contain terrible porn. Now we have Section 115 of the Copyright Act, where there's consistent orders being made in the courts to block copyright infringing material. The government's maintaining its discretion under 313, where any government agency can request that material be blocked if it regards it as a scam. So the actual, change that's been taking place, particularly in the last 10 years, where the internet's become a much more regulated space, where a lot more law in the way that it would have been seen in the 1980s has gone into what you can see and what you can do. That's an evolution. People might debate whether it's positive or negative, but it's actually bringing the internet into a much more conventional and regulated space consistent with other norms in society.
So following on from an earlier session, I think part of the mechanism that will allow it to evolve is that there needs to be more openness in the data. The way that multinationals are collecting and using data, Facebook, Google and so forth, the more that we get openness in terms of the data sets, what data sets are there, what data is being collected, how the data being used, and so forth, the more openness in regards to the data, the more that the average person, the citizens, learn about this thing called the World Wide Web. The more that business learns about this thing called the World Wide Web. And so therefore, from my perspective, the more openness in terms of the data that is being collected and utilised, traded and so forth, that will mean that there's this education and learning process. So I don't agree that government should stay out. I am a supporter of regulation of the World Wide Web. However, it is a global entity, and I'll go back again to say that I believe that there needs to be more effort made at a global level to assist in this regulation process. I believe that the vehicle is the United Nations or a body under the United Nations. I believe that we need to start from the top down and look at governance and regulation and what things can be done at a global level that will reduce the need for some of the particular actions within nation states. And in particular to resolve disputes between nation states so that it doesn't then dribble down to an impact on the way that the actual internet and the World Wide Web operate. Because as I said before, we're at the point now where if we don't see some clarity, we're going to end up with 5 or 6 separate World Wide Webs, separate internets. And do we want that to occur? Do we want fragmentation to occur? And I believe that we've got a very short window of opportunity, probably 5 years, that if we don't see something happen, then we're going to see some fragmentation that is going to be have terrible consequences leading into the future. So are there any other questions?
Yeah, as you said, there may be consequences of fragmentation. So China has already done it. It's like Weibo and WeChat, so they have safeguarded themselves. Maybe because they didn't want any spying by the American agencies or Facebook and Google. So they seem to have protected themselves, but now the question is whether the other countries want to safeguard themselves or not.
Well, that's right. So we have seen the announcement from the USSR, from Russia, sorry, saying that they are looking at separating themselves in a similar way to China. The issue then becomes one of, if you like, their associated states. Will China and Russia lean on countries to join their network and to disconnect from other networks, if you like? If this does happen, will the West cut the cable so that there's no connection to China or to Russia? That's another fear, is that will these networks separate? In other words, the cable chop, right? So there's a number of permutations in terms of what may happen over the next 10 years. And I know that the Chinese government would like to think that their network is actually separated from the rest of the world because of the Great Firewall of China. However, of course, as we know, the Chinese network leaks like a sieve, because anything digital can be connected in many different ways. And so there's an awful lot of satellites up there, and there's an awful lot of ways for people to connect into the Chinese network, not through the firewall. So the question is will that actually solve any problems? And I don't think it will. So I don't think what Russia's doing or what China's doing is actually helping. I believe, again, this is a lack of diplomacy at a global level, that we haven't got frameworks to actually limit the need for this to occur.
Just touching on satellites, if you think this problem's bad now, wait for the high altitude platform satellites and the new generation geostationary satellites, because they'll be doing high-speed broadband across very large footprints, and there won't need to be any infrastructure in the jurisdiction to do the interception and the monitoring and all the other things that telcos do. So, I mean, you anticipate either they'll be available without complete control, or there needs to be a regime where the gateways are all in the jurisdiction where the regulation is. And that's kind of crazy, because it's much more efficient with those things to have it in one place and serve everybody. So this problem happens in spades when you go to 3-4 years hence.
Are there any other questions from the audience? So I'd like to bring the session to a close, and it's the last of the industry sessions at ICEGOV 2019. I'd like to thank everyone for their participation, not just in this session, but also over the last 3 days. I think that everything has been quite interesting that's been discussed. And I'd like to invite everyone to go down now for a cup of coffee and to continue the discussions. Thank you.